the Electoral Commission against the City of Westminster Magistrates Court and the United Kingdom Independence Party.
Yes, Mr. Lawrence. May it please your Lordships, as you know, I appear with Mr. Yiginsu for the appellant, the United Kingdom Independence Party, usually referred to as UKIP, and my own friend Mr. Belloff, Queen's Counsel, appears with Mr. Dillon for the respondent, the Electoral Commission. Lords, Mr. Yiginsu, in fact, prepared an outline speaking note, which I hope might be of some assistance. I'm not sure if that's reached. It has. Good. It contains no content. It simply sets out the headings under which I hope to address your Lordships. My Lords, the case, as you know, concerns the construction of Section 58 of the Political Parties, Elections and Referendums Act 2000. That Act was passed in part in response to concerns about the funding of political parties that had led in the late 1990s to the setting up of a committee chaired by Lord Neil. That committee produced a report which your Lordship may have read and certainly will have seen references to in the printed cases. The report was followed by a white paper, and in due course, a little later on in my submissions, I'm going to invite your Lordship's attention to some relevant passages in those pre-statute founding documents that we say shed significant light on the correct construction of the Act. The section of the 2000 Act which deals with the funding of political parties, i.e. how they get money as opposed to how they spend it, represented the first occasion on which Parliament had laid down any rules at all, so far as we can find out, in relation to the raising of money by political parties. So those provisions that we will be looking at came from, as it were, from nowhere, or at least from the reports that I have mentioned. The 2000 Act made one further, a very important innovation. It established the Electoral Commission. The Commission will see the scope of its responsibilities when we look at the detail of the Act, but broadly it's responsible for the regulation of various important aspects of political activity. It came into being in 2000. In January 2007, the Committee on Standards in Public Life prepared a report on the performance of the Commission over the first 7 years of its existence, and made various recommendations which were for the most part accepted by government and were incorporated in the Political Parties and Elections Act 2009, which has made one or two changes to the part of the 2000 Act that we are principally concerned with. The institutional or constitutional position of the Electoral Commission is of interest and of some importance to certain submissions that I'm going to put before the Court. Can I take your Lordships straight away to the Committee's report on the Commission, the 2007 report? That is in Appendix 2, Sections A and B. And it's a tab 3, but that's a very bulky tab. It starts at page 200 and, pagination is rather difficult, page 268 is where it starts.
Tab 4, no?
Is it tab 4? I'm sorry, Lord, I've lost. Yes, it is, it's tab 4. It's behind tab 4. And I'm going to ask your Lordship to go on to page 293, please. At page 293, we we have chapter 1, we have the introductory passage to the report, and two-thirds of the way down the left-hand column, you will see the purpose and scope of the inquiry, and then one reads, the Electoral Commission occupies an important position in the institutional architecture designed to secure high standards and build trust in the democratic process. And one imagines that the Commission would agree with that observation. As the body charged with the regulation of political and electoral activity in this country, it stands apart from the executive, from Parliament, and from the judiciary. The position that it occupies is an especially delicate one, and the committee made some observations about that, which are of some interest. If your Lordships would turn to page 339, please. This chapter is headed Accountability of the Electoral Commission, and it starts with the familiar question. The question, who guards the guardians, is one that is often posed in the context of organisations and individuals charged with regulating the activities of government bodies and elected representatives in a democratic society. And then reading on to the next paragraph. However, in the case of the Electoral Commission, charged with the regulation of key aspects of the democratic process itself, this poses a particular challenge. The regulation of party political finances and the electoral system involves potential conflicts of interest among members of the executive and the legislature, principally the House of Commons. Regulation of these areas can directly affect the political prospects of individual MPs, ministers and their political parties. In a parliamentary democracy, it is necessary for the regulator, the Electoral Commission, to be held accountable either by the government and through it to Parliament, or by Parliament directly, particularly for the use of public money in fulfilling the statutory functions set for it by Parliament. But any system of accountability must also protect the Commission's independence and impartiality from the possibility of undue influence of partisan, political or electoral advantage. So the committee, we would respectfully submit, quite correctly identified there a problem, not an unmanageable problem, but a problem that affects the position of the Electoral Commission. It is responsible for regulating those who, to whom, on one view, it might be regarded as being accountable. And when I develop later on in my submissions an argument that I put under the heading public confidence, I will be drawing the Court's attention to other passages in this report which emphasise with great emphasis how essential it is that the Commission is impartial and, more to the point, because there's no suggestion on this side of the case that the Commission is not impartial, it is seen to be impartial. Well, that's, for the moment, all I want to show you in the 2007 committee report. I turn then, in these introductory remarks, to the way in which the 2000 Act deals with donations. Now, I'm conscious, my Lords, that Mr. Justice Walker's judgment, the Court of Appeal's judgment, and now the parties' printed cases have set out at some length the central provisions in the Act. And so I propose to take, really very shortly, my submissions as to the way in which the Act works, and then move on as quickly as I can to the gist of my submissions. Your Lordships will have seen that the relevant part of the Act prohibits, certainly this is our submission, prohibits and is designed to prohibit foreign donations, however that term may be defined. And it seeks to achieve that end by laying down specific rules in relation to donations to political parties that are made by individuals, first, and then secondly by companies. As all Lordships have seen, the position in relation to individuals is that an individual's donation is only permissible if the individual is on the electoral register at the time of the making of the donation. I mentioned in passing that the 2009 Act added a further condition in relation to individual donations. It is now necessary also that the donor must be taxable in this country on the basis that he is resident and domiciled in the United Kingdom. The position is different in relation to companies, obviously, because companies could not be on the electoral register. Company, in order to be a permissible donor, must be registered under the Companies Act in this country, must be incorporated in a member state of the EU. That was an expansion from a recommendation made by Lord Neil that was affected by the White Paper and the Act. And it must also, and this is a significant condition, carry on business in the United Kingdom. The purpose of these definitions, plainly enough, is to give effect to the recommendation in Lord Neil's report that donations to political parties should only be made by people with as Lord Neil put it, with a stake in the country. That was a policy decision that was the subject of a recommendation from his committee and was accepted by the White Paper and was accepted in the Act. And that concept, stake in the country, is an important one, which has to be borne in mind when one seeks to give a proper purposive construction to the 2000 Act. So these rules as to permissibility of donations are laid down. The Act, and a little later on I'll go to the text insofar as it's necessary to do so, but the Act contains a deeming provision. It gives political parties a period of grace, as it were, of 30 days, in which they are required to consider the permissibility of the donation in various respects. And if a political party retains the donation for more than 30 days, it is deemed to have accepted it. And if inadvertently or advertently, at the end of that 30-day period, it fails to return an impermissible donation, then two consequences follow. First, it is exposed to the risk of criminal proceedings. Under the 2000 Act, the criminal proceedings were on a strict liability basis. There was no reasonable excuse defence or anything of that nature. But as we'll see a little later on, a reasonable excuse defence has now been brought into the Act pursuant to the amending statute in 2009. That's the first consequence of the retention of an impermissible donation. The second, with which obviously we are directly concerned in this case, the second is that the retention of that type of donation exposes the party to the risk, not the certainty, but the risk that the Electoral Commission might think it appropriate to make a forfeiture application under Section 58. And as I shall be submitting in a moment, it's common ground, or observing in a moment, it's common ground in this case that the Electoral Commission has itself a discretion, as one would expect, whether to bring a Section 58 forfeiture application or not.
You say as one would expect. It doesn't strike me as axiomatic. In many countries, a prosecuting authority is under an obligation to prosecute.
Well, yes, perhaps I was, as it were, putting words into their mouth. I'm founding on various observations they've made in the course of these proceedings, which assume that they do have such a discretion.
I think it's common ground that they do.
Yes.
I'm only suggesting it's not axiomatic that they should have.
No, indeed. And certainly, as lordships have seen from the printed case, one of our arguments is that one of the unacceptable effects of the Court of Appeal's construction of Section 58 is that it affects a transfer of really the entirety of the relevant discretion in relation to Section 58 forfeiture applications to the Commission, and removes any content or any real content, we say, from the discretion which Section 58 appears to vest in the Court. The wording of Section 58 is obviously central to the appeal, and the draftsman uses perfectly simple and familiar wording. He or she has provided that the court may forfeit an impermissible donation if an application to that effect has been made by the Commission. And the central issue on this appeal, perhaps the only real issue on this appeal, can be shortly expressed. What is the nature of that discretion? It being conceded by the Commission that some sort of discretion must be conferred on the court by the use of the word may. Lords, the printed cases go into quite a lot of detail about Section 3 and about various common law principles of interpretation, and they dwell on some of the case law that relates to such matters. I'm going to have to, I think, trouble your lordships to some extent with that material in due course. But before I go into the detail or the small print of such arguments, may I invite the court to step back from the detailed arguments and to consider the broad meaning and effect of the construction that the Court of Appeal has given to Section 58. Working with my speaking note, I've now travelled to the heading on the second page, 2 discretions. I've already made the submission that the Commission says that it has a discretion as to whether to bring a Section 58 application, and we accept that it does indeed have such a discretion. So far as I know, it has not published any statement of the principles which govern the exercise of that discretion, but it has expressed its position in at least 2 places in that respect. First of all, can I take the court...
I wonder, can I just interrupt you? Is there anywhere where who are the commissioners? Why are they chosen and so on? We're about to talk about discretion, which they may or may not have.
Yes.
Who are they? I'm just looking at Schedule 1 to the Act. It's pretty uninformative.
It's
how are they chosen?
It's quite uninformative, my lord. It may be that my own friend will be able to assist more than I can on that point. They are appointed by an address in Parliament. Yeah. As it now stands, since the passing of the 2009 Act, 4 out of the 10 commissioners are directly appointed by what are called qualifying parties. And the 3 main parties, obviously at the moment, Conservatives, Labour and Lib Dems, each has a right to appoint one so-called appointed commissioner, and then the 4th appointed commissioner must get appointed in some mysterious way by one of the other parties that has at least 2 MPs in the House of Commons. So that's where 4 of the commissioners come from now. Quite how, in practice, the other 6 come to be appointed, I'm not sure, but no doubt soundings are taken between the leaders of the political parties in the House of Commons or between people delegated to deal with this matter. That's my rough understanding.
Yeah.
I will, when I take the court to the Act, I will show lordships the sections in the Act which
I've seen them.
which deal with the appointment of the commissioners. I was addressing you on the Commission's avowed discretion as to Section 58 applications. Could I take you, please, to Appendix 2, Sections C and D. Tab 11. This is the Commission's skeleton before the Senior District Judge. And could I ask your lordships to go on, please, to page 858. At the top of 858, your lordships will see paragraph 58. When exercising its discretion under Section 58 of the Act, the Court should take note that the source of the submissions and evidence in support of a forfeiture order is an independent and impartial body charged by Parliament with wide-ranging responsibilities in relation to electoral affairs. including the regulation of donations to political parties, the Court should also note that the Electoral Commission has considerable expertise in these matters and can be expected to act with a proper sense of responsibility when seeking a forfeiture order. Lord, that paragraph was the subject of a critical submission by counsel who acted for UKIP below, Mr. Newman, Queen's Counsel. He described that before Mr. Justice Walker as a dangerous submission, and by that I think he meant that he understood the Electoral Commission there to be saying, because we are a responsible body charged with these important responsibilities, the Court should attach particular weight to our decision to bring the application and perhaps to the submissions that we place before the Court. Mr. Justice Walker said that he noted and was quite happy to accept what is said in paragraph 58, but that he applied the principle that the Commission's submissions should be weighed just in the same way as the submissions advanced by any party before the courts. So that's the statement of their discretion in their skeleton. There was an exchange in the course of evidence before the district judge, which sheds further light on the Commission's understanding of its position. If your Lordships would go to tab 9 in the same bundle, please. And page 754. This is counsel, Mr. Dillon, counsel for the Commission, addressing the magistrate, and he, I think, has been asked what the position would be if a political party delayed slightly too long and only took action in relation to an impermissible donation very shortly after the expiry of the 30-day period that I've mentioned. And counsel said this at line 8. Now, I'm not going to be binding the Commission. Their discretion is a matter for them, and I think what is important is their discretion is not being challenged today. What matters is what the Court decides to do. They have made this application. My learned friend has not challenged that decision in any other forum. That, of course, is right. But to test the argument in another case, let us take the example, 31 days, you return the donation, small donation, mistake. Then it is eminently foreseeable that there wouldn't be a difficulty there with forfeiture. But that, I think, counsel meant that there would not, in fact, be a Section 58 application. But that, of course, would depend on the circumstances, size of donation, knowledge, intent, and essentially the circumstances. But that is for the Commission, and it has its own policy in terms of dealing with the matter. Now, we say that circumstances, size of donation, knowledge, intent, and so on, fall squarely within the matters to which the Court should have regard in exercising its discretion under Section 58. As your Lordships know, the Commission firmly resists that and says that such considerations simply have nothing to do with the exercise of the Court's discretion. The Commission's discretion can be described as a Stage 1 discretion, and the exercise of that discretion will determine whether an application of this type is ever made. The Stage 2 discretion is obviously that of the Court. As I've said, the Commission accepts, has always accepted, that the use of the word may in the Act means that the Court must have some sort of discretion. But the Commission has contended, and the Court of Appeal has found, that it is a very narrow discretion indeed. It's almost vanished, I shall submit. It's certainly a very narrow discretion. If I could take your Lordships to the Court of Appeal's judgment in the core volume at tab 5, please. And can I ask you to go, please, to page 200, using the pagination in the top left-hand corner.
Paragraph?
Paragraph 39, Lord, which starts on the bottom of the previous page. paragraph 39, at the foot of page 199, the core submission made by Mr. Belloff on behalf of the Commission is that once it is shown that a donation has been accepted in breach of Section 54, that is to say from an impermissible donor, and has not been returned as envisaged by Section 56, then a magistrate's court should, if asked to do so, in almost every case, exercise its power under Section 58 by ordering forfeiture of an amount equal to the value of the donation. In other words, there is, Mr. Belloff submits, a presumption in favour of forfeiture, and the court goes on to say that submission was not expressly addressed by the district judge, but was expressly rejected by Mr. Justice Walker.
It follows, does it, that the Commission should, in almost every case, ask the Magistrates' Court to forfeit?
I would have thought so, my lord, yes.
Do we have any guidelines? I noticed in the passage you referred to a moment ago, the Commission said it had its own internal policy. Do we have that policy?
We don't, my lord. I'm not aware that it's been published.
As a matter of principle, there ought to be some relationship between the factors that govern the exercise of discretion by the Commission and
yes.
the factors that govern the exercise of discretion by the court. And one would have thought that maybe the wider discretion ought to be with the court, so that the Commission would be bound to refer a matter to the court if it fell within the possibility that the court would think it appropriate that there should be a forfeiture,
yes,
rather than the other way around.
Yes. Well, you would, my lord, and that is the burden of my submissions. Anyway, so I'll be corrected if I'm wrong, but I'm not aware that...
I mean, just before we go any further,
well, yes.
is it worth bearing in mind that donation is a defined and rather wide-ranging term? And I've just been looking at Section 50, subsection 2 of the Act.
Yes.
And I mean, it covers a whole host of things, not just, here's a cheque or a £5 note. It's a great deal more than that.
Yes.
I mean, it's services, all sorts of things.
Yes, indeed, Lord. Indeed.
And so when you talk about sums equivalent to, I mean, that again, you've got to recognise somebody has to do some translation.
Yes, there are certainly some benefits that can be conferred on political parties that are treated by the Act as donations, which would take, as it were, some quantifying.
Absolutely.
In order to be translated into a forfeiture order, which may explain the language that Section 58 uses in that respect. But anyway, my lords, that was the submission that my learned friend made to the Court of Appeal, and as your lordships know, that submission was accepted really without qualification by the Court of Appeal, and one finds, I'll come back later on to some errors which I respectfully submit are to be found in the Court of Appeal's reasoning, but for the moment we can travel to paragraph 50, where Sir Paul Kennedy defines the scope of the discretion granted by Section 58. What then is the scope of the discretion granted by Section 58.2? Properly considered in the context of this statute, it seems to me to be narrow. As Mr. Belloff accepted, it might assist a party which, for reasons beyond its control, such as illness of staff, was unable to complete its inquiries within 30 days, or a party which was misled by an inaccurate entry in an electoral register. Maybe there would also be room for the exercise of discretion if a donation or its value were to be returned to the donor out of time, but before any forfeiture was sought, because Parliament clearly did not intend a party to surrender the value of a donation more than once. But in the present case, I can detect nothing which would entitle the Magistrates' Court not to make the forfeiture order. And Sir Paul went on to say that the decision of the magistrate was therefore irrational, and it was the matter was remitted to the magistrate with, in effect, a direction to forfeit.
I'm sorry to interrupt again. I
Not all.
mean, this inaccurate entry on an electoral register, I mean, assume somebody is there and shouldn't be. Does that matter? I mean, does that make it impermissible?
Well, that, I suppose, I'm not sure what the...
I thought, I mean, just looking at the Act, I thought if you're on the register, you're okay.
I suppose that somebody of the same or a very similar name might appear on the register, and the party might have been misled by that fact into supposing...
That's not an inaccurate entry.
No. Well, that would be that would be an accurate but misleading entry, which might have caused a party reasonably to suppose that the donation was permissible.
Somebody will say what the Court of Appeal meant by misled by an inaccurate one.
Well, it's not quite clear, but the general thrust of the very limited exception that is contemplated in the third sentence of paragraph 50 seems to be directed to situations in which the political party is entirely free from blame in relation to the acceptance of the donation. Now, that's all very well, but this type of situation was considered in argument before the district judge, and it's of some interest to see what was said about it, both by the district judge and by counsel for the commission. Can I ask Lordships to go back into Appendix 2 CD, please? And we go to tab 9. And turn, please, to page 727. On this page, counsel for the Commission is addressing the district judge on the subject of the nature of the discretion which, on the Commission's case, the section conferred on the court. In fact, if one picks it up on the previous page, at the foot of the previous page, 726, one finds these words: one can never exclude the possibility that there may be circumstances in which, despite your best efforts and perhaps due to circumstances outside your control, you find yourself with an impermissible donor, and that is why Parliament used the word may, not must. So that is where exceptional circumstances come in. And then counsel goes on to give an example. You go to the electoral register and you're told by the registration officer that someone is on the electoral register. You've done what you're supposed to do. You've checked the register and you're told that they are on the register. It later turns out that is wrong, that is incorrect. They were not on the register. Not likely. I think that would happen very often. But then counsel goes on, yes, that would be an impermissible donor, but does the court have a discretion in those exceptional circumstances to not order forfeiture? In my submission, in the right case, there would be a discretion. Judge Workman then took a very good point in my respectful submission. He said that sort of case would not come to court, would it? Answer, it would not. And clearly it would not, because whatever policy the Commission has formulated in relation to Section 58, it would surely provide that in cases where this extreme sort, where a political party was misled in some way by the registration officer, that the probability was that the application should not be made. So the first qualification to the presumption in favour of forfeiture that the Court of Appeal found to exist is in fact devoid of any real content, because the court will never, or almost never, be asked to consider cases where a political party has, through no fault whatever of its own, accepted an impermissible donation. Those cases will be disposed of by way of the exercise of the Stage 1 discretion that the Commission has under Section 58. So what is left of the discretion as defined by the Court of Appeal? Well, the only other example of an exceptional circumstance which would rebut the presumption in favour of forfeiture that is given by the Court of Appeal is the case in which a party accepts the donation by retaining it for 30 days, but then before the forfeiture application is made, repays the donation to the donor. Now that's a very interesting exception. I'll develop some submissions about that a little later on. I'll just note for the moment that in the course of argument in the various courts that have been that have heard this matter so far, the Commission has expressed considerable reservations about the court taking into account the fact that a donation has been returned to the donor. And the reason given by the Commission in submissions for having reservations about that as an exception to the presumption is this. They say, well, that's no good because the political party could, in this type of case, where the donor is potentially permissible simply by filling in a form and sending it to the registration officer, in this type of case, the party could simply break the law by accepting the donation, and then when it realizes it's in a little bit of difficulty, return the money to the donor, the next day or the same day accept a redonation, a second donation of the same amount from the donor, and thereby enjoy the benefit which the Commission says it should not be allowed to enjoy. So the Commission's position in relation to the second exception to the presumption that the Court of Appeal referred to in paragraph 50 is not entirely clear, but there it is. Those two exceptions or qualifications apart, the Court of Appeal does not seem to be prepared to allow for any other matters to be taken into account by the Court. Now, where does that leave this case? I'm not going to take up very much of your Lordship's time with the facts of this case. They're set out in the Statement of Facts and Issues, and of course, if this appeal were to succeed, it's possible, certainly, that the matter would be remitted to the magistrate and the fact-finding exercise would take place at that level rather than in this court. But just to give your Lordships a flavour of the way in which this case would develop if we were allowed to make full submissions to the court which holds the discretion under Section 58, the position was this. The donor here, Mr. Alan Bowen, is a gentleman in his late 60s, I think, who's worked in the United Kingdom his entire life. He was, it's a tautology, of course, he was a very successful bookmaker in the Margate area for quite a long time. He now runs a bathrobe business through a limited company, Alan Bowen Margate Limited. He's a supporter of UKIP. He started to donate, I think, in late 2003. He was on the electoral register at that time. But in December 2004, Thanet Borough Council removed him from the register without informing him that they proposed to do that. There's some issue, which I needn't trouble your Lordships with, as to whether that was a lawful act on their part, but they did it. The district judge found that that was a genuine inadvertent error.
Do you get removed from the register, or do you have to re-register yourself every year? My impression is, from the forms which arrive, that it's the latter.
I'll check this more. My understanding is there's no obligation no positive act in terms of filling in a form is required year on year.
I'm not sure you're right about that. Well, the form actually tells you have to return it.
Having been removed myself for failing to return the form, I'm pretty sure that's the position.
We'll check. I will check that one again. My junior has looked at that quite carefully, and my understanding is that there is no year-on-year requirement to fill in a form. And I myself voted in the recent election, and I haven't filled in a form for some time. So it may be that different practices obtain in different.
I'm pretty confident that different local authorities have different practices.
Yes, that may be more. Maybe. At any rate, the Borough Council in this case, Thanet Borough Council, took Mr. Bowen off the register, and as I've said, it's common ground here that was a genuine inadvertent error, which did not come to the attention of Mr. Bowen at the time, and did not come to the attention of UKIP. UKIP are taken to task here, and this would be a matter for the district judge if the case went back to him, for failing to respond promptly to queries that were raised by the Commission in April 2005, and of course that would be, if we are right about the meaning of the section and the nature of the discretion, that would be quintessentially a matter for the district judge to weigh up when exercising his discretion. There are various mitigating points. The party is a fairly small one, run on something of a shoestring. It has only 2 employees. The treasurer works full-time in the City of London. 2005 was an election year, etc. Your Lordships will see how the arguments would develop if the matter did go back to be argued fully. It was only made clear to UKIP in December 2005 that Mr. Brown was not on the register. He more or less immediately applied to go back on the register, and he was reinstated reasonably promptly on the 1st of February 2006. But during the impermissible period, so to speak, Mr. Brown donated, in round figures, about £350,000. That is the sum which the Commission seeks to forfeit. That excludes some smaller donations that were below the limit that the Act applies. These donations were properly disclosed by UKIP pursuant to the provisions, to the Commission, pursuant to the provisions of the Act. It's of some interest that Mr. Brown's company also made some donations. And if your Lordships were to open up AB, Appendix 2AB, and in tab 3, please, turn to page 80. You will find there that the standard form that is provided by the Commission, I think, to political parties for the purposes of making disclosure of donations. And UKIP has loyally filled in this form, has set out, has identified the donor in the left-hand column and the amount in the right-hand column. And on pages 80 to 81, your Lordships will see that Mr. Brown's company made, as recorded on those pages, there were other donations, I think, as recorded on those pages, his company made donations amounting to a little over £30,000, as recorded there, in the relevant period. Now, the company was a permissible donor, and the Commission rightly makes no complaint about those donations. Mr. Brown, in his witness statement before the magistrate, said, I make donations either from my own company, which is a private company wholly controlled by me, or myself. It just depends in which account there happens to be some money at the relevant time, and I write a cheque on the relevant account. Your Lordships will immediately see that if Mr. Brown and or UKIP had spotted the problem arising out of his removal from the electoral register, it would have been the work of a moment to turn the impermissible donations into permissible donations. That could have been achieved either by getting him reinstated onto the register, or simply by means of making the donations through his limited company. Lord, that's in very short outline, that's the shape of the facts which would be before the court if we were committed.
Can you just help with that latter
Yes.
scenario?
Yes.
Imagine you have a foreign would-be donor. Can he just incorporate a little company in this country and then funnel huge funds through it?
Well, that is a very interesting question, my Lord. The scope, looking at the Act as one has, and looking at some of the cases that have arisen, it's pretty clear that the scope for evasion of the prohibition that the Act seeks to make in relation to foreign donations is quite high. I will ask Lordships to consider briefly later on the much larger donation that was made by Mr. Brown to the Liberal Democrats at around the same time, as it happens. That was made through a company that he set up at around the time that the donations were being made in London. The monies came from either himself, and he was resident in Majorca and was not a permissible donor, or they came from, certainly in some cases, they came either from him or from a foreign company, which was not a permissible donor. They were channeled through the London-based company, And the Commission has given consideration to that and has asked itself whether, in those circumstances, the London company was acting merely as an agent for the principal donor, but it's concluded, I'll take a lordship to this in a moment, but it has concluded that on the facts that it has identified, there was no such agency arrangement, and the London company was to be treated as the donor under the Act. The Act does say, in terms, that if X gives money to a political party through Y, then X is to be treated as the donor. So it contains that rudimentary provision that is designed to avoid that sort of evasion. Can I have...
Section 50, subsection 8.
Thank you, Lord, yes.
But it's not just an agency situation. Presumably that subsection goes a bit further. If you gave money to a company for the purpose of it being passed on to a political party,
yes,
even if the money became, in a sense, the company's, it would be impressed with a trust to pass it on, wouldn't it?
Indeed, Lord, it would, yes.
And that would presumably fall foul.
Yes, it would.
Yeah.
It would. Well, certainly it ought to fall foul of that provision. I would respectfully entirely agree with.
But are you asking us to assume, without any evidence, that a sum of the order of £300,000 could have just been distributed by his company without any trouble with corporation tax, distributions, auditors, matters of that sort?
No, I'm not, Lord. I'm not asking this court to make any assumptions about that. And I think I put my position too high when I said that it was simply it was self-evident that the money could have been channeled through the limited company. That does, I quite agree, my Lord, that would raise factual issues that if it were relevant to do so, the fact-finding court might have to look at. But certainly the route to permissibility which Mr. Byrne could have travelled down very easily indeed, had the problem been spotted, would have been obviously to re-register himself on the electoral roll.
Is he 100% owner of his company?
I believe so, Lord, yes. Yes, he is. I'm not going to say any more about the facts at this stage, because I do submit, and my friend takes a slightly different position in relation to this. I do submit that if this appeal fails, then the facts are irrelevant because the court's not allowed to consider them. If it succeeds, then the facts would be, if it has to be remitted, about which I might say something, then the facts would be for the consideration of the court below. Lord, stepping away from the facts of this case, can I now identify three broad matters, there are others, but three broad matters that plainly cannot be taken into account by a court exercising the Section 58 discretion if the Court of Appeal's judgment stands. I've reached page 3 of my speaking note, what cannot be taken into account. And the first matter that clearly cannot be taken into account on the Court of Appeal's construction is culpability. That, the Court of Appeal has held, is irrelevant. The court exercising the discretion must treat in precisely the same way a political party which has run an immaculately tight ship for many years and which has fallen foul of the rules as a result of one slip. It may be on the part of an unpaid volunteer, on the one hand, and, on the other hand, a party that accepts a donation knowing that it is impermissible, hoping to slip it past the Commission. The two cases fall to be decided in exactly the same way. That, we submit, is would be a very strange position indeed. Second, the Court of Appeal has held that it is not...
It's a very odd scenario you postulate. If it was a foreign donor, one can understand deception. But it's hard to conceive of a situation in which somebody who is entitled to be on the register is going to set out to deceive rather than simply making sure he's registered.
Well, indeed, Lord, it is. But the submission that I was making was that the court, as per the Court of Appeal judgment, is not allowed to attach any weight to the, we would say, major difference between a party who makes this sort of inadvertent error on the one hand, and has perhaps a good record in dealing with these matters in the past, and a party which, whether it's a foreign donation or for some obscure reason a domestic donation, has knowingly accepted it, perhaps because there's some issue as to the identification of the donor, or the circumstances can vary, has knowingly accepted it, well aware that the provisions of the Act are being contravened. It does seem to us, we do submit, that it really is very obvious that the court exercising the jurisdiction conferred, or the discretion conferred by the word may, must be able to take into account such differentials. Well, secondly, the Court of Appeal expressly held that it would not be relevant not be permissible for the Section 58, the court hearing the Section 58 application, to take into account questions arising as to the impact on the party of the proposed forfeiture order, and the impact, in particular, let us say, on its ability to participate in elections. That, I would respectfully submit, is another rather startling aspect of the Court of Appeal's decision. Can I take your lordships to one European case on the position of political parties in democracies and the importance of political parties to the proper working of democracies? That case is in Authorities Bundle 1 at tab 6. This is a case called Refah Partisi, the Welfare Party, and Turkey. It concerned the decision of the Constitutional Court in Turkey to dissolve the said party for anti-secular activities that were contrary to the Turkish constitution. The passage that is presently relevant is at paragraphs 87 to 88. Starting at 87, the court has also confirmed on a number of occasions the primordial role played in a democratic regime by political parties, enjoying the freedoms and rights enshrined in Article 11 and also in Article 10 of the Convention. Previously cited case, it stated that it found even more persuasive than the wording of Article 11 the fact that political parties were a form of association essential to the proper functioning of democracy. In view of the role played by political parties, any measure taken against them affected both freedom of association and consequently democracy in the state concerned. It's in the nature of the role they play that political parties, the only bodies which can come to power, also have the capacity to influence the whole of the regime in their countries, and so on. And then reading on to the last 4 or 5 lines, the court noted that the protection of opinions and the freedom to express them is one of the objectives of the freedoms of assembly and association, and went on to observe that applies all the more in relation to political parties in view of their essential role in ensuring pluralism and the proper functioning of democracy. The court considers that there can be no democracy without pluralism. And it is for that reason that freedom of expression is applicable not only to information or ideas that are favourably received or regarded as inoffensive or as a matter of indifference, but also to those that offend, shock, or disturb. Lords, that is the propositions that are set out there are really more or less self-evident. Democracy, the effective working of democracy, must depend upon what the court there called pluralism. It must depend upon the clash of different opinions, different positions, and it is that conflict between different positions which, in theory, and one would hope in practice, would be likely to generate better policies. That is the way democracy works. Now, the Court of Appeal has said, well, never mind that. If a Section 58 application is made, the court hearing that application simply cannot consider the impact of a forfeiture order on the political party and its ability to engage in democratic processes. Can I put to the court a counterfactual example in an attempt to demonstrate that that is a quite extraordinary position for the court to take? The donation to the Liberal Democrats that I've referred to before amounted in all to about £2.5 million. That donation was made in around 2005, I think, but for various reasons, principally the fact that criminal proceedings were being taken against the donor, it took the Commission 4 years to complete its consideration of that donation. And it was in November 2009 that the Commission came to a final view about that donation. And the view that it came to was that on balance it was to be treated as having been made by the London Company, as I've said, and therefore it did not think it appropriate to bring a Section 58 application. So be it. I wouldn't say that my clients are very impressed by the comparison between that decision and the robust way in which this application has been prosecuted, but never mind that. That was the decision they took. But just suppose that the Commission had taken, as clearly it could have done, a less benign view and had brought a Section 58 application against the Liberal Democrats in late 2009. That application might have come on for hearing in the early part of this year, in the period immediately before the recent general election. And the Liberal Democrats might have wanted to submit to the court hearing the Section 58 application. This donation was made, it's a very substantial donation, the biggest we've ever had. It was received in good faith. The Commission has accepted that. The money has been spent, the money is gone. We are the third largest party in the country. We are approaching the most closely fought election in living memory. And if the court orders that we have to pay into the public purse £2.5 million, that will prevent us from engaging effectively in the general election which is coming up. We would respectfully submit that the court might or might not decide to attach weight to that submission, but it would be an extraordinary state of affairs if the court could not, as a matter of law, have any regard at all to a submission of that nature as to the effect of a forfeiture order on a political party. So we say that that's another indication that something has gone very seriously wrong with the Court of Appeal's construction of this section.
Mr. Lawrence, it's my fault entirely, but I mean, what is the purpose of forfeiture in this context? Assuming a case where there's no prosecution and so on, what is the purpose of forfeiting the donation rather than simply paying it back to the chap who gave it to them? I mean, what's the purpose?
The purposes that the Commission has identified are twofold. First, deprivation of unlawful gains or benefits. And they say that purpose is served by a forfeiture order because of the risk that if the monies are returned to the donor, they might travel in a circle and come back to the political party. And they say that would leave the party with the benefit that it should never have had. So that's the first purpose on which they place weight. And the second purpose is deterrence. They say that the function of these applications and these orders is to keep parties up to the mark and persuade the party in question and others to abide by the rules in the future.
The first purpose is not very convincing, is it? When there is an obligation to return within 30 days, which would give exactly the possibility that is said to be so significant.
Indeed, Lord. Indeed.
Yeah.
Indeed.
I mean, if the person by that time is registered, I mean, does it matter if it goes back to and he makes a further donation?
Well, indeed. our submission that if it goes back to the donor and he then makes a further donation, having corrected the clerical matter that has temporarily made him impermissible, it doesn't matter in the least, because the mischief at which the Act is directed, namely the making of foreign donations, is just not engaged at all.
Well, Mr. Orange, I mean, of course, the primary purpose, no doubt, of the legislation is to guard against foreign donations and to make sure that...
Yes.
But there is an underlying purpose, surely, in forfeiture, and that is that Parliament has decided that the way of policing the primary purpose is that you only accept donors from those on the register.
Yes.
And it's a sanction. It's to promote that safeguarding policing mechanism by which this Act operates.
Yes. Lord, I would entirely accept that, and I entirely accept that there will be many cases in which it is proper for the perhaps necessary for the Commission to make the application, and it will be proper for the Court to make a forfeiture order. It might be, this is one of my submissions, it might be, on certain facts, appropriate for the Court to make a partial forfeiture order, because that would serve the deterrence purpose. That would be sufficient to keep parties up to the mark, but would not involve the disproportionality which will often be involved, will often arise if a full forfeiture order is made. But
that seems to me a very important point. The two aspects go together, don't they?
Yes.
Can you make a partial forfeiture
Yes.
order? And if you're right as to the overall way that the Act ought to work, then that would carry with it a very strong inclination to read the Act in such a way as to permit a partial forfeiture order. If you start at the other end and say you can't, then it's quite difficult to have a system that turns on proportionality, because...
Indeed, my Lord, indeed. Yeah. We're responsible, I think, because we started it in our petition. We've divided up, the parties have divided up the construction issues into two halves, as it were, all or nothing, and presumption. But thinking about the case in advance of this hearing, it became increasingly clear to me that the two issues are really merged into one and had to be taken together. Well, the third matter which I identify at this stage as being a manifestly relevant consideration, which the Court of Appeal has expressly held cannot be taken into account by the court below, is the simple question: is the donation in question a foreign donation? Is it within the mischief at which the Act is clearly targeted? And I'm going to address your lordships on the identification of the mischief at which the Act is targeted in a moment. And so, if I may, I'll just note that the Court of Appeal has held expressly that the court cannot have regard to the question whether the donor is, as it were, foreign or domestic. Lords, at this point, if I may, I will invite your attention to what we see as the relevant passages in the Neil report, in the white paper, and then in the Act. The Neil report is at tab 2 in part 3 of the appendix. Lord Neil's committee sat for 25 or 30 days, so far as one can tell. It took a lot of evidence from many people involved in the political world. The report contains a summary of the relevant proposals at page 186, using the bottom left-hand pagination. This is section 9, elements of our proposals. And just scanning these, one sees that there are recommendations about full public disclosure of donations above a certain limit. That has happened. An end to blind trusts. The third bullet point is the key one: donations to political parties to be allowed only from a permissible source, defined so as effectively to ban foreign donations. Then a ban on anonymous donations that obviously fitted with the, the rules about disclosure. And then further recommendations as to expenditure, with which we're not concerned at the moment, accounts, state funding. There was no recommendation of substance in relation to state funding, and other matters to do with finance for opposition parties, access to television, etc. Your Lordships will see what is said there. Then at section 10, under the heading Election Commission, we find this: the extensive changes we propose have convinced us of the need for a totally independent and authoritative election commission with widespread executive and investigative powers, and the right to bring cases before an election court for judgment. Reading on, we envisage the commission taking over responsibility for the registration of political parties. That happened. And in conjunction with the existing network, having broad oversight of the conduct of elections, which is still the case. Then, if your Lordships would turn, please, to page 190. We find here a summary of the recommendations as to foreign donations. Political parties should in principle be banned from receiving foreign donations. They should only be taken from a permissible source. And then the recommendation as to the definition of a permissible source. As to individuals, registered UK voters and those entitled to register as UK voters. And as your Lordships know, that was a recommendation which government departed from in the White Paper and then in the Act. The definition was narrowed, for reasons that we will see in a moment, to include only registered UK voters. Entitlement to register was not enough. Then, if your Lordships go please to page 196. There is there a summary of the recommendations in relation to the Election Commission. And I would in particular emphasise paragraphs 74 and 75. The Commission, 74, the Commission should not be a court or have any substantial judicial power. 75, the Commission should be and be seen to be an independent and impartial body. Its members should be chosen on a non-partisan basis and by means of a non-partisan procedure. Its members should nevertheless be acceptable to the leaders of the main political parties. Then, if the Court would go please to page 208. At the top of page 208, the committee, rather as the European Court of Human Rights did, emphasises the importance of political parties, and the points made there are similar to those that we've looked at already. Then under the heading Public Opinion and the Funding of Parties, the committee observes that there is a delicate relationship between the funding of political parties and public opinion. In 1880, apparently, in real terms, £106 million was spent on the election, double what was spent in 1997 in real terms, which is interesting. Then if one reads on to the foot of the page, 2.6, what problem, the question is posed, the answer is far less clear-cut than it was in 1880 and 1922. There is no overt corruption in the constituencies, no overt trade in honours, yet in broad outline what today concerns the public is the inscrutability of the sources from which the parties derive their money. People ask who is paying and how much, in return for what. Is it British or foreign money? No satisfactory answers are vouchsafed. I think I can then move on, please, to page 252. We've now reached the chapter that directly deals with foreign donations, and on page 252, the arguments in favour of a ban on foreign donations are summarised. I won't read all of this out, but if your lordships would notice, please, the last 4 lines of the first paragraph, which summarise the gist of the argument in favour of a ban. Put in its simplest form, the argument is, what happens here is the concern of those who live and work here, and the political parties should not be entitled to fill their coffers with donations from abroad made by persons and corporations who have no genuine stake in the country. That is the key phrase, who have no genuine stake in the country. The report then summarises the views of the major parties. Each of the 3 major parties was in favour of a ban on foreign donations. The nationalist parties were not, for the obvious reason that they received significant support from expatriate Scots and Welsh, but their views did not prevail. The question of forfeiture is first considered on page 261. I'm very happy not to. My learned friend has asked if I'm going to omit 255. Yes, thank you. Yes, at 255, definition of foreign donation, we began by attempting to produce a definition of a foreign donation which would be reasonably simple to operate and free from ambiguities. The difficulty with that approach is that it is necessary to cater for all manner of exceptions. For example, the mere fact that money is received by a political party from overseas would not be within the spirit of a ban on foreign donations if in fact the money came from an expatriate UK citizen who happened to be working for 6 months in Geneva. And your lordship will see how that... Certainly, I'm asked to read 5.19. This and other similar difficulties persuaded us that it would be more constructive to approach the problem from the opposite direction and to attempt to define what was to be regarded as a permissible source from which donations may be received. The text then under the heading permissible sources goes on to make the recommendation that we have already identified, namely that for individuals the criterion should be eligibility to be put on an electoral register in this country. And I was then, I think, unless my own friend wants to dwell on that, was going to go on to page 261. Now, at 261, there is an important paragraph, 5.42, under the heading Enforcement and Penalties. This needs to be read quite carefully. In essence, what we said in Chapter 4 should apply here too with necessary modifications. Thus, the Election Commission will have statutory powers to call for information and to institute an investigation into any donation which it suspects has not come from a permissible source. if a party were to be guilty of a deliberate acceptance of a donation from a source outside the definition of a permissible source, criminal sanctions should attach to all responsible, and a sum not less than the donation should be liable to forfeiture from the party's funds. In significant cases of attempted evasion of the rules, a penalty of up to 10 times the overspend might be levied. A forfeiture power should also apply even if the receipt were innocent or inadvertent, although the courts would clearly take into account the degree of culpability in setting the level of forfeiture. Now, if I may, I'm going to, bearing that paragraph in mind, I'm going to leave the Neil report for a moment and ask your lordships to look at the treatment of that recommendation in the white paper. And one can find that in the same bundle at tab 1, page 28. It's paragraph 4.15. In addition to these criminal sanctions, the government also accepts the committee's proposal that where a party is found to have accepted a donation from other than a permissible source, it should be liable to forfeit that sum. Clause 51 provides a power for a magistrates' court, or in Scotland the sheriff, to order the forfeiture of a sum equal to the value of a donation received from other than a permissible source. This will apply whether such a donation was accepted knowingly or not. Under Clause 51, 2, it will be for the Electoral Commission to make an application to the court for a civil forfeiture order. So, the Neil Committee made a recommendation that fell into two parts. It recommended that in cases where there was a deliberate acceptance of an impermissible donation, the court should have a draconian discretion to forfeit up to 10 times the sum in question, and a sum not less than the donation should be liable to forfeiture. So there would be a minimum that would have to be forfeited in cases of deliberate non-compliance, contravention of the rules. The committee made a separate recommendation that there should be a forfeiture power where the receipt was innocent or inadvertent, but just said in passing, as if it was completely obvious, as we would submit it should be, that in such a case the courts would clearly take into account the degree of culpability in setting the level of forfeiture.
I'm sorry to interrupt you.
Yeah.
415 refers to R31. R31, which is tab 2, page 261, seems only to deal with the criminal sanctions.
Yes, the Lordship is absolutely right. The recommendation R30 is irrelevant. Recommendation R31 is in fact a rather incomplete summary of the text at 542. But when
415 misstates R31.
It does, yes. It misstates R31 and it collapses into one sanction, the dual structure that the Neil Committee plainly was contemplating. Now,
presumably, it's a method of cross-referencing to the relevant part of the Neil report, really.
It is relevant, yes.
Isn't it?
Yes.
Because it's quite clearly not dealing with R31, it's dealing with the substantive paragraph 5.42.
Indeed, no, that is...
But it doesn't actually accept that either, does it?
No, it doesn't. It doesn't really address...
Neither accepts R31 nor paragraph 542.
No, it doesn't. It doesn't. It doesn't address directly or expressly the dual structure that the committee had in mind. It just simply collapses it all into one potential sanction, which
And the
would
10 times point
that's gone.
was dropped.
That was dropped, Lord. Yes. So
Basically, if it's accepting anything, it's accepting a forfeiture power should also apply, even if the receipt were innocent or inadvertent, and then it's adding, dealing with the whole of the previous bit, or even if it's intentional.
yes, Lord. Yes. Yes, more. I'll look later at the treatment by the Court of Appeal of the shift between the Neil Committee and the White Paper in that respect. If I can go back, please, to the Neil report and take you to page 333. (11.6), we ought perhaps to state explicitly that there is one role which we do not envisage the Election Commission playing. A number of our recommendations involve the creation of new criminal and civil penalties, and there already exists, in any case, a substantial body of justiciable electoral law. But we do not envisage the Election Commission in any way functioning as, or substituting itself for, the ordinary courts. The Election Commission should not be, or be thought to be, a judicial body. Recommendation: the Commission should not be a court or have any substantial judicial power. And one, I think, can infer that the forceful terms in which that recommendation is made relate to the committee's perception that it would be very undesirable for the public to perceive that the Election Commission was assuming judicial powers over the various matters that are dealt with in the Act. Now, this recommendation obviously is very potentially very important, because the effect of the Court of Appeal's construction of Section 58 is to give the Commission de facto very significant quasi-judicial powers in relation to matters relating to forfeiture. The court is turned in almost every case into a rubber stamp once impermissibility is established, and everything turns on the decision taken in the Commission's committee room as to whether an application should be made. So it's fair, I think, to say that the Court of Appeal's construction is contrary to the recommendation at 11.6, recommendation 74. The White Paper does not, I think, deal expressly either way with this recommendation, but we would submit that the Act was drafted in terms that reflected the recommendation that it should be the courts that exercise judicial powers in these matters, and not the election, and not the Commission. That, we say, is the obvious meaning of the wording in Section 58. The court may make a forfeiture order if the Commission chooses to bring an application. My Lords, could I then go back to the White Paper, please, and look at one or two other matters in that. That's at tab 1. Could I go, please, to page 10, using the left-hand pagination. paragraph 2.3 on page 10, the functions of the Electoral Commission are crucial to maintaining public confidence in our democratic institutions. It is vital, therefore, that the Commission is wholly independent of the government of the day and is seen to be scrupulously impartial in its dealings with the political parties. To ensure that this is the case, the Commission will not be a non-departmental public body on normal lines, but will be directly accountable to Parliament. The bill provides for distinctive machinery for appointing the members of the Commission and setting the budget, which will help reinforce its independent status. Then, if we could move on, please, to page 26, we find there the passage in the white paper which deals with permissibility and which changes, which involves a departure from the committee's recommendation. 4.5, towards the foot of page 26, the Neal Committee recommended that those who are entitled to register to vote should be permissible donors. Clause 50(2)(a) departs from this recommendation by providing that registered political parties may accept donations only from those individuals whose names appear on the electoral register. Entitlement to register, whether as a resident or overseas elector, will not qualify an individual as a permissible source. Checking that a particular donor appears on the electoral register offers a test that is both conclusive and simple to administer. It would be far less straightforward for political parties to verify that a donor not appearing on the register was nevertheless entitled to do so. It is in the interests of the parties to have available a test which offers certainty as to the eligibility of a donor. With the introduction of rolling registration, it will be open to anyone who is entitled to be registered as an elector, but was not on the register for whatever reason, to take the necessary steps at any time to secure his or her registration. Once registered, it would then be open to a party to accept a donation from such a person. In practice, therefore, little is lost by the proposed departure from the Neal Committee's recommendation. It's entirely clear, we say, from the text there, that the reason for the change from eligibility to be on the roll to actual appearance on the roll was one of administrative convenience and was one relating to the desirability of the parties having a simple test that they would find easy to apply.
Paragraph 4.1 is of some interest.
Yes. I was going to submit more than 4.1 supports the submission. I was going to submit that there is no hint at all in 4.6 that the change in the definition of permissibility was in any way arose from a change in the perception of the underlying mischief. The mischief at which the Act is targeted remains exactly the same, namely the receipt of foreign donations.
And the last sentence of 4.6 could be relied upon as underlining that, because you wouldn't say little is lost if you thought that, in fact, you were introducing a positive and beneficial change which had a substantive content.
Yes. So that was the change, and that was why the change was made. I think I can pass over the passage relating to companies for the moment, and ask the Court to go over one page to page 28. Where we find, in fact, we've obviously looked at that already, where we find the passage at 4:15, which deals quite cursorily with the recommendation as to forfeiture proceedings. There's nothing else in the white paper that I want to look at. If my learned friend is anxious that anything else should be drawn to your Lordship's attention, I will do so. But absent that, I will ask your Lordships now to turn to the Act itself, which is in Authorities, Volume 4. The most efficient way to look at the Act itself might be to turn up the appellant's case in the core bundle at tab 3, please. It may assist if I use the summary of the Act's provisions in the printed case as a guide to the relevant sections of the Act. The printed case takes up or describes the Act, begins the description of the Act at page 77, paragraph 32. And at page 78, paragraph 33, we have identified the 10 separate parts of the Act. Those that are directly relevant for your Lordship's purposes, I think, are Part 1, which deals with the Electoral Commission, and obviously Part 4, which deals with donations. Then at paragraph 34, we describe the sections dealing with the Electoral Commission. Sections 1 to 4 deal with the setting up of the Commission, the appointment of commissioners, the setting up of the Speaker's Committee and the Parliamentary Parties Panel. Under the Act as it originally stood, there would have been no fewer than 5, but no more than 9 commissioners. That number has now changed to 10, pursuant to the 2009 amendments. Section 2 of the Act sets up the Speaker's Committee. That consists of the Speaker, the Chairman of the Home Affairs Select Committee, the Home Secretary, a Minister, and 5 other MPs. And the Speaker's Committee has various duties that are imposed by Schedules 1 and 2. It has to report to the House, it receives the Commission's accounts, it monitors the budget, and so on. Section 3 provides for the appointment of commissioners, and perhaps I should go to that. That is in Authorities 4. At page 3.
Sorry, tab 50.
So what are we looking at?
The appointment of commissioners, my lord, which section 3.
Oh. Yeah.
The appointment takes place by means of an address from the House of Commons. There are various prohibitions on the identity of those who may be appointed commissioners. I don't think the details matter really for present purposes, but the general thrust is of some interest. There are prohibitions on members of registered parties being commissioners, on those who've been employed within the last 5 years by any registered parties, and so on. It's evident that the intention is to ensure, to some extent, that the commissioners are seen to be independent of the parties. However, pursuant to the 2009 amendments, as I said earlier, the position has changed somewhat. If your Lordships go over the page, you'll find section 3A. And 3A provides for 4 electoral commissioners to be persons put forward by the parties. These are the so-called appointed or nominated commissioners. And 3 of those commissioners are to be nominated by the 3 main parties, the 4th by some other party with representation in the House of Commons. And one infers that the increase in the number of commissioners to 10 was designed to ensure that the 4 nominated commissioners could not operate as a majority. Then section 4 sets up something called the Parliamentary Parties Panel. That consists of representatives of qualifying parties. Subsection 9 defines a qualifying party as a registered party to which 2 or more members of the House of Commons for the time being belong. And the function at subsection 2, the function of the panel shall be to submit representations or information to the Commission about such matters affecting political parties as the panel think fit. And subsection 3 imposes a duty on the Commission to consider such representations, etc.
What is the corporate nature of a political party?
Of a political party?
Yes. How does it own property, if it does, and can it be wound up?
I may be wrong, and I should know the answer to that. Mr. Beloff, I'm sure, will. It's not a corporate body, I don't believe. It must be an unincorporated association. Mm. We'll check, my lord, to see if that's right. I'm not wholly sure of my ground, but that's my understanding. The Parliamentary Parties Panel is obviously established so that the parties that have representation in the House of Commons have a right of access to the Commission. Whether they use it, I don't know, but the statute contemplates that they can use it to make representations and so forth. There's no similar right conferred by the statute on other registered parties, such as my clients, who do not have at least 2 MPs in the House of Commons. Those are the provisions at the start of the Act relating to the constitution of the Commission that I wanted to go to. I think we can then go on to part 4, which deals with donations, and that starts at page 51. As my Lord Brown observed, section 50 defines donation broadly to include sponsorship, subscriptions, provision of services, facilities, property, etc. That's of interesting part of the context. Subsection 8 of section 50 is the provision that I referred to earlier. Any reference to anything being given or transferred to a party or any person is a reference to its being so given or transferred either directly or indirectly through any third person. That's clearly designed to catch the case of the foreign donor who channels money through a permissible donor in this country. We can then pass over 51 through to 53 and move on to section 54, page 55. Section 54 defines permissible donors, and the key definitions are at subsection 2, little a and little b. Your lordships will see those definitions.
If the donation is in the form of a bequest, when is it that the testator must be registered?
I'm afraid, my lord, I don't know whether the Act deals expressly with that matter. Or maybe I do. Maybe it's subsection 3. In relation to a donation in the form of a bequest, subsection 2a shall be read as referring to an individual who was at any time within the period of 5 years ending with the date of his death registered in an electoral register.
It's odd, that, in a way.
It is, isn't it?
It is, yes.
Especially in the context of the facts of our case.
It is odd. I think one can then move to section 56.
My impression
because if Mr. Brown had died, the position would be quite different.
Indeed it would, my Lord, yes. But happily, he's alive and well and in court, so you can't take advantage of that.
My impression is that you can be registered in an electoral register, as was touched on earlier, quite wrongly. But you would be eligible under this Act. Presumably there'd be some other Act which either made you liable for some offence or the person who'd registered you. I mean, it can happen quite easily.
It could happen, Lord, yes.
The forms in those boroughs, at any rate, where forms are sent round, are pre-completed.
Yes.
Unless you delete a name, you can easily allow it to remain.
Yes, it is a questionable feature of the whole structure of this regime, that could indeed happen. And if one was wrongly on an electoral register, as I read the Act, you would then be a permissible donor, full stop. There might be other, as Lordship says, there might be other sanctions, but that's the way it would work. Section 56 is important. It deals with the 30-day period that parties have to consider the permissibility of a donation. It starts where a donation is received and it is not immediately decided that the party should refuse it. All reasonable steps must be taken forthwith by the party to verify, or, insofar as not apparent, ascertain the identity of the donor, whether he is permissible, and, if that appears to be the case, all such details in respect of him as are required by virtue of paragraph 2 or 2A of Schedule 6 to be given in respect to the donor of a recordable donation.
Where do we find that?
That was introduced by the 2009 Act.
Is that right?
As I recall, that relates to arrangements between individuals.
I mean, is that right? I mean, footnote 116 doesn't talk about 2009 Act.
No, I'm sorry, my Lord, your Lordship is quite right. I'm wrong about that. And I'm looking for Schedule 6.
It's at page 206, 207. That can
Thank you, Lord.
205. It goes back a bit.
Paragraph 2. Where's that from?
That's
Yes, page 202, isn't it?
Yes.
So, basically, what does this require?
Name.
Quarterly report.
that's the thing we're looking at.
Yes. These are the reports that the court has seen, or an example of which the court has seen.
Yeah.
Quarterly report setting out the information at subparagraphs 2 to 10, 12 and 13. Then subsection 2 requires the name to be provided and his address as shown in an electoral register. Two A deals with Gibraltar. Subsection 3 deals with bequests.
Well, I mean, well, it's just looking for the basic, and I think it's 2.
It's 2, my Lord,
2,
yes.
isn't it?
It's 2. The other, over the page, the other paragraphs deal with different types of donor. So it's name and address, in short. Going back to section 56. Subsection 2 provides that if the party decides that the donation is impermissible, i.e. prohibited by Section 54, or if it decides for some other reason that it should be refused, then it must be sent back to the donor within 30 days of receipt.
But the obligation to repay depends only on receipt, a prohibited receipt.
Yes.
It's an absolute obligation.
Yes, you must repay within 30 days.
Whether you know you have that obligation or not.
Yes. And the deeming provision that I referred to is subsection 5 over the page. That provides that a donation shall be taken to have been accepted unless the steps mentioned in subsection 2, i.e. return within 30 days, have been taken.
Yeah.
So if you hang on to it for 30 days, under the Act you are deemed to have accepted it. So it is quite a stringent regime, and as originally drafted, the criminal sanctions were on a strict liability basis. Subsection 3 deals with that. Subsection 3 provides that where 2A applies, i.e. the donation should be sent back, and it's not dealt with in that way, then the party and the treasurer are guilty of an offence.
And where are the penalties?
I'm sorry, Lord?
Where are the penalties provided for?
They are provided at the back of the Act,
Yes. Way at the end.
I recall.
Yes, way at the very end somewhere. It's in the miscellaneous section, isn't it?
It's section 150, punishment of offences, and schedule 20 sets out the penalties, and schedule 20 is at page 334.
It's interesting, the Court of Appeal described these as more draconian than the forfeiture provision.
Yes.
But I suppose that's true insofar as they provide for imprisonment.
Yes.
But so far as the fines are concerned, the position is quite different.
Well, it would be, my Lord. Indeed, certainly on summary conviction, the fine would be limited. I don't have the precise figure. I will get that. But it would be limited. And of course, the forfeiture order that the Court of Appeal is contemplating in this case is far more draconian in financial.
It wouldn't be open to the criminal court to order forfeiture.
No, it would not. So,
But it could presumably have regard to the amount in deciding what the fine should be, I suppose.
well, it would.
At least it would, you would say, I suppose, that at least there would be a discretion to decide what the appropriate fine would be.
Indeed. The sentencing court would have quite a wide-ranging discretion in relation to financial penalty, which...
It wouldn't be stuck with a fine of the, even on indictment, of the amount of the donation, having regard to the purpose of the act.
It would not. It would not be stuck with that, my Lord. It would have a pretty wide discretion.
Oddly, given the Court of Appeal's analysis of the purpose of the act.
Yes. Well, that is.
Well, you combine the two, and I mean, you'd have both criminal and civil.
You can, Lord. Yes. The 58 expressly provides, I think, that yes, subsection 4 of 58 expressly provides that a forfeiture order can be made whether or not proceedings of a criminal nature have been brought.
How does forfeiture work? if UKIP has spent all the money, what happens?
It is effectively bankrupt. The monies that are to be paid pursuant to the forfeiture order have to come from the political party's funds. UKIP at the moment, as things stand, it does not have such funds in its possession, so it would be effectively a bankrupt political party.
Well, effectively bankrupt. I don't quite know what that means.
No, well,
let's imagine 100,000 comes into the kitty next year. Does the forfeiture attach to that, or does it simply drain any funds that are held by the Treasurer on behalf of the party?
No, the party would be, under the Act, the party would be liable to pay the sum in question. That liability would remain in place until discharged. And so if a donor provided money in 12 months' time, and there was an outstanding sum under the forfeiture order, that money would have to go into the public purse.
When you say the party would be, bearing in mind what you were saying about its status a moment ago, individuals, the committee?
Well, that's interesting conceptual question. Can I deal with that at 2 o'clock?
It's not very conceptual, it's a rather practical one.
Presumably you have to start out...
It's a relevant practical one, but nevertheless, can I deal with it at 2 o'clock?
I mean, my impression is that even the main parties are very often in deep debt. I mean, they're quite unable to discharge their debts that day.
Perhaps you have to start out UKIP 2000 and X.
Yes, that might not play very well with the electorate, my lord, but that...
You never know. That's what they thought of the forfeiture order, I suppose.
Just add to the European bankruptcies.
Lord, these possibilities can be conjured up, but there's no doubt, I think, in practice, that a very substantial forfeiture order would be somewhere between highly inconvenient and disabling for a fairly small political party. The criminal offence, as I said earlier, is now subject to...
And who's the prosecutor?
The CPS or the DP...
But not the Commission.
CPS, not the Commission. No. The Commission is not given responsibility for criminal proceedings.
I don't understand that's not been yet tested.
What, who the prosecutor?
Clearly the ones who Madam Friend referred to as capable of prosecuting. Your Lordship will know there's a certain amount of jurisprudence on whether statutes are the moment the Commission have not pursued that.
Might be a private prosecution. I could prosecute. Could I?
I'm not going to be tempted to answer
Nor am I, Lord. The statutory defence that now exists since 2009 is at 3A. It's a defence to prove that all reasonable steps were taken and that the Treasurer believed the donor to be permissible. So that is now the position. It wasn't the position at the time of Mr. Bowen's donations.
And do we get anything at all from the fact that civil proceedings, I mean, it says from Scotland that at the end of application, subsection 5, proceedings and application, civil proceedings, the appeal to the Court of Session and so on. It's got no criminal aspect to it at all, this forfeiture.
Indeed, Lord, no. It's a civil action. It's not a criminal action.
58.
So it's not quite clear to us which section we're on now.
Yeah.
58. I was looking at 58.5.
My Lord had moved on to section 58.
Sorry.
Where's the 3A that gives the statutory?
3A is at the foot of page 59 in section 56.
I see, thank you.
That's the statutory defence to the criminal charge.
But conspicuously, no such defence introduced in respect of of the non-criminal forfeiture.
Indeed not, my Lord, no. Then that brings us to 58. Subsection 2 is very simply worded. The court may, on an application, order the forfeiture by the party of an amount equal to the value of the donation. The civil standard of proof applies. We've looked at subsection 4. As my Lord observed, they are to be treated as civil proceedings. Section 59 provides a right of appeal to the Crown Court, which can only be exercised by the party, not by the Commission. And that, if it took place, would be a rehearing in the, what I think is the normal way of appeals from the magistrates to the Crown Court.
I mean, do we deduce anything from the fact that Parliament chose not to give a right of appeal to the Commission?
It's all one deduces from that, I think, is that it is one-sided and appears to recognise that the political party may have advanced arguments to the magistrate which have been considered and rejected, and therefore it's appropriate for the party to have a right of appeal. It's little difficult to square the unfettered right of appeal to the Crown Court with the very limited, very narrow discretion that the Court of Appeal has held to exist. I don't think, my Lords, there's anything else in 59 and 60 which is directly relevant. 65.
Yes.
Thank you. Yes, it's that subsection that I was thinking of when I said that the amount forfeited had to be paid out of the funds of the party. But what is left open by that is what is the consequence if it's not paid?
Yes.
Very well. Shall we adjourn until 2 o'clock?